بسم الله الرحمن الرحيم الحمد لله رب العالمين اللهم صل على سيدنا محمد النبي الأمي وعلى آله وصحبه أجمعين. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to another episode in our series on Al-Qawa'id Al-Fiqhiyya, Islamic legal maxims. Today we're talking about a maxim that is specifically related to financial issues. It's considered one of the most important principles that applies to Islamic economics in general and Islamic finance in particular. It is al-kharaju bid-daman. And the wording of this maxim, which means it's translated as benefit goes with liability, the wording of this maxim is derived directly from a statement of the Prophet ﷺ. So its primary application is to sales. That was the context in which the statement was originally made. But it also has relevance to rental contracts, guarantees, agency, partnership, rahan, which means pledge. And it's a reflection of this overarching Sharia principle of justice and fairness. So the twinning, the inseparability of these two issues of entitlement to profit and responsibility and liability for the source of that profit, this is a hallmark of the Sharia and just recurrent throughout the rulings of the Sharia related to transactions. As far as the words that make up the maxim, the first is kharaj. It literally comes from a word kharaja. It means to go out or to leave. So to come forth from, to emerge from would also be meanings of kharaja. So kharaj, it means yield, return, or revenue. And in the context of the maxim, it relates to separable benefit or corpus resulting from an owned asset. And we'll get into that, the breakdown of that which emerges from an asset, the different types in a minute. And daman means responsibility, liability, or guarantee. And it has a number of different meanings in fiqh terminology. In this context, it means liability for an asset in case it is damaged or destroyed. So what the maxim is saying overall is that the benefit from an asset is the right of the person who would be responsible for it if it were damaged. So for example, in a sale contract, in certain sales, the buyer agrees with the seller that he will have an option. He'll take this good home and he'll have 3 days or whatever to make up his mind about whether he wants to keep it. So if he returns it during the option period, the seller cannot charge him rent for his use of the asset during that period, because when he took it out of the store, he is liable for it. If it were to be damaged while it's in his possession, then he would either have to keep it or pay the owner if he wants to return it. For instance, like it's still usable but its value is reduced, he would have to pay for that. So the fact that he is liable for it while it's in his possession means that he wouldn't have to pay rent to the owner on that basis. Now, with regard to the increase that comes from an asset, it could be logically divided into 4 categories. The first is an increase that occurs and is inseparable from the asset itself. You have a tree and it grows bigger. So the extra wood that becomes part of the tree over the period of time is an increase that is inseparable from the tree itself. And then you have a kind of an increase that it develops from the thing itself, but it is separable. So, for instance, fruit from a tree, it can be plucked, tree is still there, the fruit is now independent of the tree. Milk in the udder of a cow or a sheep is separable, things like that. And then you could have property to which humans add something. So a person buys a piece of land and then builds a house on it. So that house is some added benefit that didn't arise from the land itself, but it arose through human agency. And that is attached to the land. You can't really move a house. And then you have benefit that arises from an object in the sense of revenue. You own a house and you rent it out, so that revenue is a kind of a kharaj that is derived from the benefit, and it's not of the same type at all of the asset itself. The asset is made out of bricks and glass, and the benefit is in the form of cash. So the maxim applies to this separable benefit from the original asset. When you look at the issue of domain or liability, there are a couple of causes that trigger liability in the Sharia. One is damaging another person's property. So you're driving down the road and they stop suddenly and you hit them from the rear. That's your fault. You're automatically the one who bears liability for that accident because you were following too close. So you have to pay for the damages. Also, if you take possession of an asset while having the ability to handle it and dispose of it. So that's if you're taking possession of it for your own benefit. If you take possession on behalf of the owner, you're not liable. So for instance, somebody leaves something in the safekeeping of another person and there's a flood. You know, he put it in his house and the flood is force majeure. It's circumstances beyond his control. He's not liable for that. Also, entering into a contract can lead to liability. When you enter into a contract, you assume the liability to do certain things. So in that sense, you're obliged to do something because of the contract. And also, liability can arise when one of the parties violates the terms of the contract. In that case, the other party can sue for damages. So now, this maxim applies to a person who takes legal possession of an asset for his own benefit, that because of the liability that he undertakes for the asset, then separable benefit that goes with it would be his right. Conceivably, one could say, well, wait a minute, you know, a person who seizes another's property, which in Arabic is called a ghasib, you know, he's also liable for that property. But because he took the property without the person's permission, he doesn't have right to any profit that arises from it, even though he would be liable in case of damage caused to the property while it's in his possession. So this maxim doesn't apply to people who take things unlawfully. It is people who take possession by a legal right. One exception to this rule, based on the hadith of the Prophet ﷺ, where he said that nobody should stop milking a camel or a sheep for a couple of days before selling it. And the reason that people would do that was in order to make it look like, you know, the sheep had a lot of milk, because its udders would look full, and if the buyer tested it, the milk would spurt out in a vigorous stream. So the buyer thinks, oh, this is a good animal. So he would buy it, and then he'd take it home. The Prophet ﷺ said if somebody had that happen and then he sees that, wait a minute, you know, this animal doesn't yield the way I thought it did, we're going to take a break here and come back, inshallah.
ذو الجلال.
ألف كتاب أنزلناه إليك لتخرج الناس من الظلمات إلى النور.
Allah Ta'ala revealed the glorious Quran as a guidance, light, and cure.
إن هذا القرآن يهدي للتي هي أقوم.
But have we understood this great book as Allah wants us to do?
إنا أنزلنا عليك الكتاب للناس بالحق.
What are the techniques to contemplate on the Quran?
فمن اهتدى فلنفسه ومن ضل فإنما يضل عليها.
How do you memorize the Quran and keep it in your heart?
ولقد يسرنا القرآن للذكر فهل من مدكر.
What are the right ways to benefit from the healing power of the Quran?
I am a Muslim.
I, Ahmad ibn Sayfuddin, will answer these questions and more in my series, The Etiquettes of Dealing with the Glorious Quran, here on Peace TV.
Perceive the parameters which make the understanding of the Quran crystal clear in The Etiquettes of Dealing with the Glorious Quran, every Monday at 7 p.m. and repeat telecast at 12 p.m. India on Peace TV.
Where truth is hidden and misleading quotations create confusion. Where truth is hidden, lack of knowledge and wisdom cause upheaval and commotion. Where truth is hidden, manipulated scriptures and twisted facts emerge. This very hidden truth creates false propaganda, mayhem, chaos, disorder, and turmoil in our lives and the world order. But is there anyone with courage and wisdom? What is the truth, and who has the courage to expose it? Because it's your right to know the truth.
Watch truth prevail and lies perish in Truth Exposed by Dr. Zakir Naik every Sunday to Friday at 9 p.m. and repeat telecast at 7:30 a.m. India on Peace TV. A night of decree is better than 1,000 months. The benefits of worship and the vigil in the night of power.
Ramadan, which is the topic of the show. Do you have any advice for our viewers?
Asad Ahmad,
Especially in the blessed month of Ramadan.
The Ramadan is the reminder of rectifying our behavior.
Dr. Ali Shaban,
Ramadan is a unique opportunity for every Muslim.
and the reasons behind this revelation and its power emphasized as the human heart transcends towards godly glory.
If you apply Ramadan to the rest of the year,
Tariq Ali
surely you are going to be much, much better in all fields, all aspects.
and the gratitude of the soul reaches out to worship the Almighty One on this esteemed night.
Just to stick more and more of the time to the Holy Quran.
Dr. Muhammad Ibrahim,
This is my advice to all my Muslim brothers.
let's strive to seek the night of power and its bliss in Blessed Nights every Friday at 4:30 p.m. and repeat telecast at 3:30 a.m. India on Peace TV.
ذو الجلال.
So we're talking about the situation where a person, he bought an animal for milk, takes it home, discovers that the udders were full, but now it's not giving the milk that he expected it to. So in that situation, he can return it to its owner, and the Prophet ﷺ said he should also pay a sa', which is like a double, this is a mud, so 2 of those worth of dates to the owner of the animal when he returns it. And the reason for that is that that milk that he consumed was in the udder of the animal when he bought it. So it didn't arise from the source while he was liable for it, which is why he doesn't have a right to it. So he has to compensate the owner or the seller for that. And if we look at what it is that the Sharia considers as causes for a person to become lawfully entitled to profit, one of them is labor, one of them is capital, and the other is liability. So for instance, if a seller charges a markup on a murabaha sale, he tells the purchaser, look, I bought this for 10, I'm going to sell it to you for 15. And the purchaser agrees, that's a valid contract, as long as the seller is honest about what it cost him and the other party agrees to the markup. So the seller is entitled to that markup because he's gone to the effort of going and finding it, and while the good was in his possession, if it was destroyed, he would bear the liability for its loss. And in a mudaraba contract, you have an entrepreneur without capital and you have a capital supplier. Each of them has a right to the profit that arises from the venture based upon his contribution. The entrepreneur is contributing his labor. The supplier of capital is supplying the capital needed for the enterprise. And if there's a profit, they split it. If there's a loss, the entrepreneur has lost his time. He's not allowed to charge like a salary or to demand a salary for doing this task. He's invested his time and effort expecting a return. So if there's a loss, he lost his time and effort. On the other hand, the capital provider would bear a loss to the capital. So you see that the capital provider, he is entitled to profit from two angles, that he's supplied the capital and he's also borne liability for the loss to that capital. And so both of them have a right to the profit based upon what they've contributed and what they're liable for in case of loss. And as we mentioned earlier, that this maxim is derived from the statement of the Prophet ﷺ, al-kharaju bid-daman. That's a hadith narrated by the Ashab al-Sunan. And also you have a statement in another hadith where the Prophet ﷺ, he said, this is just a portion of the hadith, he said, la yahillu, he mentioned various things that are not, various kinds of sales and transactions which are not lawful. And at the end of that list was, وَرِبْحُ مَا لَمْ يُضْمَنْ. Profit is not lawful from that for which one has no liability. So this mentions the flip side of the first hadith. And one example of the application of this in classical fiqh is called shirkat wujuh. So the way this would work is that two or more partners who don't have any capital, but they're of good reputation. So people trust them to purchase on credit. They come together and say, okay, let's make a partnership. We'll purchase such and such items on credit, and then we will sell them. And each of us will be liable for a certain percentage of the price when it comes time to pay that delayed payment, deferred payment for those goods. So they agree to this, they purchase the goods, and they sell them and hopefully earn a profit, and then they can pay for the goods that they purchased. So this is a kind of contract that's lawful according to many of the schools. Some of them don't allow it. But those who do allow it, the reason for allowing it is because they identified that what these people are contributing is the willingness to be liable for those purchased goods. And therefore, they have a right to the profit. Now, in the Hanafi madhab, they said that's the reason for the contract being lawful in the first place. Therefore, if somebody assumes 50% liability, but then wants 60% profit, they said, can't. Because his percent of the profit has to be pegged to his willingness, the percent of liability that he's willing to assume. This is a matter others disagreed with because there are other elements that go into that partnership also because labor is involved. So it may be that one partner does more work than the other. Now, this sounds a little bit strange. I mean, we were kind of straining for examples of this, but if a person bought a computer and used it during that warranty period or something, and then something went wrong with it, gave it back, and he used the computer and he generated some kind of valuable intellectual property, the seller of the computer can't say, wait a minute, you know, this property, you produced it on this computer, which I own, and therefore I should get a portion of your profit when you sell it. That kind of a claim would be invalid because while the computer was in the possession of the buyer, if it had been damaged, he would have been liable for it. So he has the full right to the profit from that intellectual property. An example of this maxim where it works in reverse is a mudaraba situation. You have a capital provider and you have an entrepreneur. And the capital provider, he gives the capital to the entrepreneur, the mudarib, and he says, but I want you to guarantee it. And I also want a share of the profit. That's no longer a mudaraba contract. What that is a loan. So, you know, the famous statement of Umar ibn al-Khattab, he said, "Sammuhu ma shittum." Call it whatever you want. That doesn't change the reality of what it is. You're calling it mudaraba, it's not mudaraba, it's a loan. Once the capital becomes guaranteed, then the mudarib becomes liable for it, then all the profit is the right of the mudarib. The capital provider, he doesn't have a right to a single cent of that profit. In the remaining time, let's just mention briefly that there's a flip side to this maxim. There's another maxim. It says, al-ghurmu bil-ghunmi. Liability accompanies gain. So just as a person has a right to benefit because of the liability that they accept, if a person wants to get profit out of something, they have to accept the liability. So this is the twin. These two maxims are like the flip sides of the same coin. So let's look at some of the applications of this. A condominium is like an apartment, except that each unit is owned by the person who buys it. He may then rent it out, but to begin with, each unit is owned by a purchaser. So these condominiums hire security guards to maintain safety for the people who live there. They hire janitorial staff to keep the premises clean, those kinds of things. Now, the management of that condominium is providing those services on behalf of the owners. So who's supposed to pay for the janitorial service? It's definitely the responsibility of the condominium owners, not the management. Another example of this in fairly classical fiqh terms, let's say that a person borrows an asset and then they travel somewhere and then they call up the owner and says, hey, I got your asset and you can have it back now. Come and get it. No. The borrower is the one who derived benefit from borrowing the asset. So it's his liability to return it back to the owner. We mentioned earlier that the widespread custom is that a buyer is the one who pays for the fees required for transferring the title to a house or a car, whatever. And why is that the widespread custom? Because the buyer is the principal party that benefits from having the law or the government recognize that he is now the rightful owner of that property. Because it's to his benefit, then it makes sense that he's the one who should bear the expenses for the title transfer. If somebody pledges an item, you know, they've purchased something and they're now going to pay for it over time. So they pledge an item in order to secure the payment on behalf of the owner. If there are any maintenance costs or storage costs associated with that item, they should be borne by the owner of the item. He doesn't relinquish ownership of it because it's a rahan. That's in Islamic law. Apparently there's differences between Islamic law and certain Western systems of law in that regard. We've come to the end of our time. Thank you for listening. Assalamu alaikum wa rahmatullahi wa barakatuh. Wallahu a'lam.